I think the key issue is that some of the funding requirements of this plan, in fact, continuing to operate the hospital, are dependent upon accounts receivable income, which is continuing to come in, but is also under jurisdiction of the bankruptcy court.
Sure. And I'll speak very briefly to this, but essentially, faced with mounting demands by creditors and the inability to pay the debts as they were coming due, the district board voted earlier in April, I guess, to determine there was no choice but to file bankruptcy. The second time, unfortunately, the district has had to do that in the last 7 or 8 years, and seek protection from the creditors, protection by the bankruptcy court. This began the process of putting into place a Chapter 9 bankruptcy proceeding. The Chapter 9 proceeding goes through 2 stages. The first stage is eligibility, in which the court confirms that the district is in fact eligible for bankruptcy protection. And then the next stage is what we call a plan. In a Chapter 9 case, which is what a government entity files, such as Palm Drive, the plan is called a plan of debt adjustment. And that is a plan that will have to be ratified by the court and will be voted on by any of the various creditors in the case. And as we move forward through the bankruptcy process, it's incumbent on the board in its capacity as fiduciaries and as us moving forward to look at the cash and the receivables that are coming in and make sure that those are available to be dedicated to the plan, whatever it may be. And what we need to ensure is that we can't raid the cash that's coming in for services that have been provided in the past to leave us down the road without the ability to put forward a plan that we can get approved by the court. And so the necessity here is to ensure that we don't raid the kitty, so to speak, and spend more money going forward without knowing that money will support what the plan will be and what we'll be putting in front of the court. So that's what the core bankruptcy issue is in terms of where we're going and this process. And it leads to the notion that if we're going to move forward on something that's going to cost more money, at least in the startup phase, although I recognize there are projections, and I'm not the expert on what may or may not work in the proposal and whether these services can be provided and generate revenue, but at least in the startup phase, there needs to be new money offered to get this off the ground. And what the proposal did was look back to the existing funds of the district, or the AR of the district, which actually needs to be addressed through the bankruptcy, and say, well, we're going to use those funds to get started. And those funds, the bottom line is those funds just aren't available to start up this new process. Therefore, we're recommending that to the extent that the board were to envision moving forward with the foundation, either in the very near term, keeping the doors open, or in the longer term and working towards a plan after the hospital goes dark for a while, it needs to be based on an infusion of cash that's independent of the funds that need to be dedicated towards the bankruptcy plan that the district will be embarking on.
And I'd like to make my comment and ask Michael Sweet to correct me if I'm wrong. My understanding is that it's not that those funds are unavailable, it's that we are accountable to the court in how we use them. And if we use certain funds that are short-term to do the restart and use some funds that might be available a few months from now to take care of the creditors, as long as we are acting reasonably, that the court may well go along with that. Michael, am I incorrect in that?
Jim, conceptually, that's correct. If you look at places like Stockton or Detroit, who are continuing operations that have filed bankruptcy, have specific revenue available to them, ongoing revenue they know they will receive, and are able to articulate that and make projections for that those receivables. In both cases, it would be the kinds of money that comes into the city through the taxes that fund all their operations, as opposed to here where a significant part of your funding comes from the operations of the hospital that you need to get paid for service. Then it's easier to articulate a way to use the funds going forward, through the operations. The complexity here, and Jim, what falls on the shoulders of yourself as well as the other members of the board, is your role as a fiduciary and the knowledge that right now that money is available, and the concern that the money could end up being squandered or spent on something that the return isn't clear, and could leave us in a very complicated situation down the road if money was available today to pay the creditors and fund the plan and exit the bankruptcy, and that money is spent in a way that the court might conclude was done imprudently. So the situation here is one where the operations would need to be shown to support the replacement of that revenue. And ultimately, the concern that the financial analysis is that while there's a possibility that it's there, because there isn't certainty on the projections, I think that the board puts itself at risk as a fiduciary for doing that and could create complications for us in the bankruptcy case going forward.
Hey, can you stay there for a second, Michael? It is my understanding, we have the ability to collect a basket of money from a number of sources. We have our accounts receivable, we have the Medicaid 2011-2012 catch-up payments, we have the next couple rounds of parcel tax, which the county is going to advance to us, and those are relatively sure pieces of revenue. We also have, as potential, the freeing up of the withheld money from previous bonds. That's less certain. And my understanding is that it is our responsibility as fiduciaries in the bankruptcy to demonstrate to the judge that of this pot of money, X% is going to go toward the new startup and Y% or continuing operations of some sort, and Y% is going to go toward doing what we can for the creditors. Is that not essentially correct?
That's essentially that in a nutshell is the plan process in the bankruptcy. The problem is that the ratification of the plan in the bankruptcy and the vetting of the plan by the creditors in the court is not something you do in 3 days, which is the complexity here. So if the board puts itself ahead of that freight train and makes a decision that would spend the funds now in anticipation of proposing a plan with the hope that it all works out, is where I think the problem arises. What I think is the prudent step for the district to do is put together a plan with cash flows that are supportable through analysis, with expert testimony to present to the court. Because recall, the district has, is it 4.5 or 6, the total creditors outstanding?
About $6 million.
Almost $7 million in debt to creditors. And they get a say in the plan. And they get to go to the court, and one of the things they'll probably say in the court is this district doesn't even deserve the right to spend $1 on operations unless we get paid in full. Now, I'm not saying that the court won't give you some leeway there, but that's going to be the starting point of the discussion with the creditors in the bankruptcy plan. And so your starting point is coming up with $7 million, and then articulating a basis to carve some of that out for continuing operations, and not to spend a lot of money now on operations that by the analysis I've seen, albeit very cursory and quickly prepared, is speculative, and then leaving yourself in a situation where the money that might have been available for creditors is no longer there, and then you've got $7 million worth of creditors who are looking at less. So that's the complexity. But Jim, essentially what you've articulated is the plan process in bankruptcy, and our goal would be to move the plan process forward. And when we started this, Chris talked about, how are we going to reimagine ourselves? What are we going to be as we exit this? And I think that's what everyone wants to figure out is, what is this district going to do to offer services that are consistent with the mission of the district, but also recognize the reality of providing healthcare in West County in the 21st century with the other facilities that are nearby, and with the costs and reimbursements being what they are, and the facility being in the shape that it's in. So I think everyone agrees that at the end of the day, where this goes is a plan to the bankruptcy court where we articulate a basis to continue to move forward with provision of health care in West County on a budget that we can support with projections that can be proven, and at the same time providing something to the creditors. So that's where we're going to go. That would be my hope. That's where generally you would go in a Chapter 9 case like this. But it's going to take the analysis that will have to bear itself out.